begin, let me ask you a question, guys. As law students, we have spent years studying legal concepts, case laws, and procedures in classrooms, right? But have you ever wondered how these concepts translate into real world practice and what skills are truly required beyond academic knowledge? And how can students prepare themselves for a successful career in law? So, today's session is designed to answer these very questions. This session will provide practical insights into understanding legal terminology, interpreting legal texts, developing effective reading techniques, and building the ability to navigate legal language with confidence. So, before that, I'm going to introduce the Collective Council to you. Today's session is organized by the Collective Council, a platform dedicated to bridging the gap between legal education and legal practice through practical learning initiatives, mentorship opportunities, skill based programs, and career focused training. So, our objective is simple to help law students and young legal professionals develop practical skills, gain industry exposure, and prepare themselves for successful legal careers. So, let me now introduce the speaker of this session. It is now my privilege to introduce our esteemed speaker for today's session, Advocate Sanskruti Mahale ma'am. So, Sanskruti ma'am is a distinguished professional known for her expertise in legal interpretation and legal drafting and her dedication towards mentoring aspiring lawyers. Through her professional journey, she has guided numerous students and young professionals on understanding real world practice and skill. On behalf of the Collective Council, I extend a warm welcome to you, ma'am. So, without any further delay, I would like to hand over the session to Advocate Sanskruti Mahale, ma'am. Over to you, ma'am.
Thank you, Dikshita. Thank you for the introduction. Hello, all. I believe we can start with the session. So I'll quickly present the screen to you all and then start the session. Is the PPT visible to everyone?
Yes, ma'am.
Yeah.
Yes, ma'am.
Okay. So let's begin. So the topic for the session is reading legal language, which also talks about decoding acts, judgments, and case files. Right. So as the introduction is already done, I'll move on to the slide. The very first module of this session is reading Bare Acts. What is a Bare Act? Bare Act is like an primary source of law, right? And first thing first, I would really expect all of you, all the participants, to participate in the session, right? I would really like if you can participate and answer whenever there's a question. You can just drop in your answers in the chat box, right? And if there are any questions, I would expect that you ask it towards the end of the session. Since I'm presenting the screen, I cannot view your questions. So I'll take all the questions towards the end of the session. All right. Can
Yes, ma'am.
someone? Yeah, okay, perfect. Okay, so why read a Bare Act? First and foremost, I would really like to know that how many of you have read Bare Act from first page to the last page? Like, do you all read Bare Acts from first page to the last page? What I'll do is I'll enter the meeting from my phone as well so that I can see if you have your responses. Okay, so without further ado, so Bare Acts are not like novels. Bare Acts are generally reference documents that lawyers use. Okay, so Bare Acts are generally divided into a like a typical statute which is followed by different parts. So in the beginning, a Bare Act will have a long title, and the title generally tells us what the purpose of the legislation is, right? So you open any Bare Act of any law, The first thing that you'll see is the title, and the title will generally tell you what is the purpose of the legislation. So generally we face everyday court matters may we face this problem of maintainability, whether a particular petition is maintainable. So how do you know if that particular petition is maintainable? Is whether it the legislation explicitly explains if that particular petition stands or it doesn't stand. So it is important for you to read what the purpose of the legislation is. Then the preamble. The preamble will generally help you know what was the legislative intent, right? Why a particular law was enacted. So the preamble will tell you about that. Then we move on to the second most important section, that is the definitions. So generally section 2 would contain the definitions, and definitions are very, very important. Like most of the students will underestimate this section. However, general meaning of a term versus the legal meaning of a term is in entirety different, right? So, for example, a vehicle in normal ordinary parlance would mean something that transports people, right? So it could be a car, it could be a bike. However, the legal meaning would be construed in a very broader sense, right? So the legal meaning overrides the ordinary meaning. Then we move on to the main provisions. So what does a main provision of a Bear Act tell us, right? So main provision generally tells us about the rights, tells us about what are the duties, what are the powers, what are the liabilities, and what the offense is. So main provision is the main part wherein you will get to know about the rights, the duties, the powers, the liabilities, the offense, etc. Right? However, the definition clause will support it so as to understand the main provision better. Right? Then the main provision is generally followed by the schedules. And most of the students again ignore schedules. However, some of the most important or hidden information is stored in the schedules, right? So the examples are what are the forms, the classification, then the procedural details. So all the procedural details are generally explained in the schedule of the main provision, right? So what is the golden formula? So in general, a golden formula for reading any section is step number 1, to identify the subject. So who is the section talking about, right? The section is talking about, example, whoever commits theft, right? So the definition of theft, wherein it is whoever commits theft. Now, who is the subject here? The subject is whoever, right? So it is not defined as to a male, a female, whoever will commit that particular offense, which is of theft, right? So you identify who the subject is as step number 1. Then in step number 2, you generally identify the action. So the action here is theft. Whoever commits theft, action is theft. Thirdly, you identify if there are any conditions, like if that section speaks about words like if, when, provided that, subject to. You have to be very, very cautious about these words because these words are kind of triggers. So a simple sentence and when such words like where, when, provided that, subject to will generally change the meaning of what really looks very simple, right? Then you identify the consequences as step 4, like what happens if conditions are satisfied, which means if all the section conditions that I have explained so far, like step number 1, you identify who it is, step number 2, then step number 3. Now, step number 4, if all the 3 conditions are met, what would be the consequence, right? So generally it will explain about punishments, or if there is any right that is given through the section. So it will explain about the right, any liability, or any exemption if that particular section provides. Then you identify what the consequences, right? So herein the formula is who, what, the conditions, and the consequence. That is basically how you should dissect a section to know the meaning of it in entirety, right? The simple formula is who, what, the conditions, and the consequence, right? Now we move on to the most important words in statutory interpretations. Generally, the entire section, the entire meaning, and entire way of how you pursue a case changes with these words, right? So that's pretty much the difference between when a layman would draft a particular agreement or any contract versus when a lawyer would do it, right? So how you do this distinction is by using words, because words which are legally like used have a different meaning, and words like shall and may etc have a very generic meaning in ordinary English, right? So common man's drafting versus a legal person's drafting stands out. That's why we focus on a few words that basically change everything, right? So you'll generally see in a section that words like shall is used, right? Normally ordinary English, shall has a simple meaning, right? However, in law, shall means mandatory. The authority shall issue the notice, which means it is mandatory on the authority to issue the notice. There is no choice that the authority has here, right? Then word like and means all conditions must be satisfied. It's not so example, grave and sudden provocation, right? Herein, there is no choice of if one part of it is met, that grave was there but sudden was not there, right? So the very famous Came Nanavati case was decided on this very principle, that the exception grave existed but it was not sudden. The entire preparation time that was taken behind the murder gave it the gave it a different meaning altogether. So the word and, grave and sudden provocation, meant that all conditions must be satisfied, that it had to be grave as well as sudden, right? Then we move on to the third word, which is may. May in legal parlance means discretionary, right? The authority may issue notice. May means the authority has discretion. There is no compulsion on the authority to issue a notice. Then we have or. Any one condition is enough, right? So whenever a section will say or, it will tell us that it is any one condition, either this or that, right? So then there is includes, right? Many a times in the definition you will find word like includes. So includes would have a broader meaning, right? I can go on taking examples, but then the session would really get uh, delayed, right? And this is a basic session. So the word includes would have a broader meaning, right? And the word means would have a very fixed meaning. So you say, like if I read out a simple definition from the Maharashtra Public Trust Act to you, a trustee means a person who either alone or in association with other person, the trust property is vested and includes a manager. Now here the definition is very limited, right? It is fixed. It has an exact meaning of who a trustee is, right? So these are the words which may look very simple. However, they really change the meaning in a case, and you can actually fight an entire case basis these words which look very simple in ordinary English. Now, what not to miss while reading Bare Acts, right? So the most ignored parts of the Bare Acts are provisos, the explanation, the exceptions, right? So the proviso, how to identify a proviso? The proviso usually starts with words like provided that. Proviso creates an exception to the main rule. So whenever there is a rule, main rule, right? And when there is a word provided that, right? It changes the meaning. It creates an exception to that section. I'll give you a simple illustration that if there is a main rule, no appeal shall lie. That is the main rule, okay? No appeal shall lie. And the proviso says, provided that an appeal may lie with leave of the court. Now the proviso becomes crucial, right? So many students make this mistake that they stop reading the proviso and they just focus on the main rule. However, proviso is equally important because the proviso could be creating an exception to the main rule. So you don't ignore it at all, right? Then we follow explanation, and it usually starts with follows the main text. Now, explanation will give us the meaning, the true meaning, right? Then we have exception, usually starts with stated explicitly, etc. And it removes certain cases from the rule. So it again more gives it in a more structured manner what the exception is, right? So the golden rule here is never stop at the first full stop. Always check for provisos, always check for explanations or exceptions that are mentioned in the section, right? Now here I've given you a very simple example of theft, right? And how every section is broken into ingredients, okay? So if you look at the definition of theft, right? And if you break it down, you'll find number one, there has to be a dishonest intention, right? There has to be a movable property. The property should be belonging to someone else, right? And without the consent of that person, and the property has to be moved. So all these ingredients are essential for it to be construed as theft. If any of the ingredient is not present, the lawyer can basically argue that this is not a theft, right? So it is important that when a definition or when a section is explained, you go through and break it down into different ingredients and see if all the ingredients of that sections have been met, right? You can go on to read an entire case brief, but the basics is where you can really trick the case, right? So what is the final takeaway here is you basically read, right? You read from the starting, you basically read what the preamble is, what the title is. You read what the definitions are, because the definitions are uh, they are like a basic premise to your main sections, right? Your main provisions. So you read definitions, equally important. You go through the main provisions, right? You break it into ingredients, you find exceptions, and you then connect the related sections. So once you go through this flow, you will understand law in a very different manner, right? Rather, because it is no novel. Law is no novel that you just glance through it. So a Bare Act, like I've mentioned towards the end, a Bare Act is not meant to be memorized. It is meant to be understood. Right? Is this is everyone following the session? Can someone just
Yes, ma'am.
yeah, perfect. So let's move on to the next part of the session, which is understanding judgments, right? So ratio decidendi versus obiter dicta. Right. So if a Supreme Court judgment is, say, 500 pages long, does every sentence become law? No. Only some parts are legally binding, right? So it could be a 500 pages long judgment, however, only two paragraphs could be binding and the rest could be persuasive, right? So why this matters to us, right? So lawyers rely on precedents and judges follow binding principles, right? We have seen in cases we generally give case laws, right, which are kind of binding principles on the judges. Then not every observation and judgment is law. So understanding this helps read cases intelligently. So somebody could be using a case law and arguing on a part which is merely persuasive and not the law itself, right? So when you can identify that, you can actually argue that the case law does not apply since this is merely persuasive. Merely persuasive, it's an obiter dicta and it's not a binding law, right? And understanding this helps for you to read cases intelligently and make uses of them in real life while you are standing before a judge and arguing a matter, right? So judgment is divided into two parts. One is the ratio and one is the obiter dicta, right? The ratio becomes the binding law and the obiter dicta becomes a persuasive observation. Now, simply, what is ratio decidendi, right? So, ratio in its literal meaning means reason for deciding. It is the legal principle or rule that was necessary for deciding the case, right? So, what would be the basic characteristics? It would include it was necessary for the decision, it was binding on lower courts, it is eligible to form as a precedent, it creates a legal rule, right? So generally, facts, legal issue, plus essential reasoning will give us the ratio. I'll give a simple example, not a legal one. College has authority to enforce reasonable discipline. Compulsory ID cards, right? So here let's say that the students must wear ID cards. The college rule has been said that the students must wear ID cards, right? But a student refuses to do so. The principal punishes him. The court here will say that the college has authority to enforce reasonable discipline. Therefore, compulsory ID cards are valid. Now, this principle becomes the ratio. Next time, when any student will not wear an ID card, this rule or this principle will be followed and that will act like a precedent, right? Now we move on to what is an obiter dicta. Obiter dicta is generally like the meaning of it is things said by the way. These are observations, comments, examples, warnings, suggestions, or opinions which are made by the judges that were not necessary to decide the case, right? So, when I first explained about how a judgment could run into 500 pages, there could be barely few paragraphs which become binding, and everything else which were like observations, comments, examples, warnings, suggestions, or opinions are all a part of obiter dicta. Okay. Now, what could be the characteristics? It persuasive? It is definitely persuasive. It may influence the future law, right? It may create a way for any future developments, right? However, during deciding the case, it is not binding and it is not essential for the decision, right? Now, I would like to continue the same example that I previously mentioned, the ID card case. Suppose a judge additionally would have said that in future, colleges should also consider biometric attendance. Here, the case did not require biometric attendance, right? So, obiter dicta merely told how it could influence a future law. However, in this present case, the whole biometric attendance part was not a part of ratio, right? So basically, the ratio is like a tree trunk. Without the trunk, the tree falls, right? And the branches become the orbiter. Without branches, the tree still stands. However, it is persuasive, it may influence, but it is not binding. I've carved out a few important cases, famous cases, wherein ratio and orbiter, what is the difference between the two, you'll be able to understand in a better manner, right? The first case is Don versus Stevenson. Okay, excuse my pronunciation if it's wrong. So here the ratio which was carved out in the case was that manufacturers owe a duty of care to the consumer. Okay, one second. Yeah. So basically, what was the important issue here? So in this case, this is basically a famous case of snail in the ginger beer bottle, right? So the facts of the case were that Don drank a ginger beer and later on he found a decomposed snail in it, right? And then became ill. Now, the question in the case was whether it was right for her to sue the manufacturer despite having no contract with him, right? So, here the ratio that was decided in the case was that the manufacturers owe a duty of care to consumers, and the arbiter, which was given in the case, was broader comments on future developments of negligence law were mentioned in the arbiter, right? Then we have our very famous Keshwanand Bharati versus State of Kerala, right? Here the ratio said that the parliament can amend the constitution but cannot destroy its basic structure. Arbiter had wider discussions on constitutional philosophy and democracy, right? Then we have our Maneka Gandhi versus Union of India case, wherein the ratio was any procedure restricting liberty must be fair, just, and reasonable. And the arbiter had broader observations regarding human dignity and constitutional laws. So we have ratios which are binding, and then arbiter, which were parallel discussions that happened while the case was decided.
Ma'am, could you please repeat the orbiter? Orbiter,
Yeah,
sorry.
arbiter.
What does exactly orbiter mean?
Okay,
The
okay.
ratio
I'll
is
tell you. I'll
binding,
tell
so
you.
orbiter is?
Yeah, I'll tell you. So any case, right? So you see any judgment, be it Supreme Court, be it High Court. The judgment runs in hundreds and thousands of pages. But the entire 100 pages is not binding. The entire 100 pages do not become the law, right? So a few sentences or a paragraph here and there would become the law. So let's take the example of Keshananda Bharati versus State of Kerala, right? Here the binding principle that was derived from the case was that the parliament can amend the constitution, but it cannot destroy its basic structure. Now we all know that Keshananda Bharati is a long, long judgment, right? The entire part, other than what was the ratio or what was binding, becomes the arbiter. Is it clear? I don't know who asked the question because
Yes,
I
ma'am,
cannot.
it's
Yeah,
clear. Thank
yeah.
you so
So
much.
yeah, so basically, arbiter is observations, comments, examples, suggestions, or any opinions that judges make, which are not necessary to decide the case, but are generally persuasive or can help in future law. Okay? Now, how to identify ratio and arbiter, right? So there's this golden 3-question rule, okay, as to how to decide between the ratio and arbiter. So the first is, what was the issue before the court? That is the most important part while you read a judgment, right? You go through the facts, then you go through the issues, then what reasoning was necessary to decide that issue, right? So that is ratio decidendi, as to what reasonings may formed a part to decide the case, right? And what observations could be removed without changing the outcome. Now, anything which is in excess of what was necessary to decide the case, anything that is an observation or example or a suggestion, all becomes obiter dicta, and everything else other than what was necessary to decide the case becomes obiter dicta, right? So the takeaway is, ratio decidendi is the binding legal principle, and obiter dicta are persuasive observations, not essential to the decision, right? And generally, it is a little difficult for lawyers to find ratio. It is not always easy, because when you see constitutional cases, right, with multiple judges, like constitutional cases will have 5 judges bench, 7 judges bench, right? And 5 judges will write something separately. 2 judges will disagree with something. A few judges will agree partly, right? And then lawyers will spend years of their lives arguing what exactly is the ratio. So this issue generally happens when it's a constitutional case, when there are judges having different opinions. So that's where the ratio finding is a little difficult, but these are the like 3 rules wherein you can find what ratio and what an arbiter is. Should I move on to the third part of the session, or there are any questions? I'll wait for a minute. If no one interrupts, I will move on to the third part of the session. All right.
Okay,
So
ma'am.
navigate. Sorry.
Ma'am, I just said okay, ma'am.
Okay. Okay. Perfect. Okay. So navigating case files. That's the third part of our session, right? So what all does a case file have? A typical case file will contain pleadings. It will contain written statements or replies, as we say it. It will contain affidavits, exhibits, orders, and correspondence. We'll dissect each of it, right? But these are the important components, or every case brief will have all of these, okay? So how do you dissect a case file, right? You have generally, when there is a case file or when there is a case, you'll have certain questions, right? You'll have questions like, what happened, what is disputed, who said it, who proves it, or what proves it, and what will the court decide, right? Now all these questions are answered through your case brief or through your case file. Your what happened is generally mentioned in your pleadings, right? Your pleadings and your written statements will tell you what happened and what is disputed, right? So your pleadings and your written statements will help you answer questions, what happened and what is disputed, right? Now, who is saying that will be explained through affidavits, right? A person who is submitting his written statement or a person who is submitting his plaint will have to submit their affidavits along with their plaint and their written statements, right? So affidavits will act like an oath that whatever I have said is my stance, right? So who has said it? That you'll understand through affidavits. Then there'll be evidences, right? Every plaint, every written statement will be followed by tons of documents which will be attached. These documents will act like evidence, right? And these evidences will help prove the written statements or the plaint. Then both of these will be read, gone through, and the issues will be identified, which the court will decide, right? So, whatever would be the legal issues, those would be decided by the court, right? So, here is a golden rule which says that you basically read the story first, right? You understand what are the things. So, general practice, what I generally follow or what most of the lawyers follow would be that whenever you have a case before you will the start from the timeline, right? You will, whatever was the first incidents, from there you will start and you'll come to the end, right? So you'll build a storyline in your head, which will be followed through a timeline, right? And this timeline will be supported by documents, right? Which will become a part of your evidence. And that's how you basically go through the case. Right. So, what are the pleadings? First and foremost. So, pleadings tell the court what facts are asserted, what relief is sought, and what facts are admitted or denied. So, the pleadings will be telling us a story which will mention what are the present material facts. It will define what the dispute is, and it will also tell what relief is sought through the pleadings, right? So these will be the components of any pleadings. It will have the facts, it will tell us what the dispute is, and it will, towards the end, it will seek for a relief, right? Now in a plaint, right, what will you generally look for? You look for who the parties are, what the cause of action is, what are the key dates, like I mentioned earlier, what relief is sought, and what is admitted and denied, right? So when you are going through the pleadings, these five are the key essential things that you have to notice. What are the parties? Who are the parties? What is the cause of action? So what happened because of which the dispute triggered, right? So what was the cause of action? Then what was the timeline? What dates were followed? The first incident happened on this day, second on this day. What are the dates? Then what relief is sought from the court towards the end? And what admissions or denials are made all become a part of your pleading, right? So let's take a simple example as to a plaintiff is saying that it was a loan, right? And the defendant was saying it was an investment. Now, the real issue that the court has to decide here is what is the nature of the transaction, right? So here you basically the court will basically decide what the nature of the transaction was, whether it is a loan, whether it is an investment, and how will the court decide it? Through the pleadings and through the written statements, and whatever documentary evidence are submitted to the court will be able to decide basis that, right? Now we move on to affidavits, that is the witness on paper. Now an affidavit answers who is making the statement, who do they know, how do they know the facts, and are the facts consistent. So an affidavit will generally tell the court that what facts are known by a particular person, who is making that statement, and whether these facts are consistent, right? So all the affidavits of people would be submitted, whoever is giving the written statement or the pleadings, and these affidavits will be checked by the court, and the court will watch for missing facts, contradictions, assumptions presented as facts, and unexplained timelines, right? So these things are also important to form the legal issues or to decide the matter. So whenever there is a case briefs and you go through the affidavits, you have to look for what are the missing facts or any contradictions, or if the timelines mentioned are wrong or do not align with your case, because that's how you can carve out the case, or during your cross examinations, etc., you can ask questions. So affidavits or your written statements will be your key documents to identify contradictions and important facts which are not mentioned or tried to be concealed from the court, right? So basically, again, like the slide says, that if this person was to be cross-examined tomorrow, what would you ask first? And how do you know what would you ask first? So affidavits will often reveal the weaknesses that pleadings hide, right? So you cannot ignore affidavits. They are important for you. Evidence, simple. It's, can the story be proved? And how can the story be proved? There are different types of evidences. You'll have your documentary evidence, you'll have oral evidence, and you'll have electronic evidence, right? Suppose the fact says that a loan is advanced. Then what would be the supporting documents? The bank transfer, or if there are any loan documents that have been signed, correct? Then if agreement was executed, is what the fact says. Then you'll have to show if an agreement was signed between them or a contract was entered into by the parties, right? So this would become a part of the supporting evidence. Or if a client says that we have already made a demand, however, that person is not ready to give us our money back, right? So you have to prove the court that how have you made the demand earlier. So you might have issued them a legal notice or triggered an email trail asking for your money, right? So these all become part of your supporting evidence, right? So any allegation which is not supported by a proof makes your case weak. Any allegation with proof, a strong case is made out, and the fact is also stands its grounds before the court, right? So every strong case has to pass this checklist, that there should be consistency. Consistency between what? Consistency between the pleadings, the affidavit, and the evidence. They all have to sing the same tune. A pleading cannot be on some different tune, an affidavit on entirely different, and evidence on a different. If a consistency is not followed through, your case becomes weak. So it is essential that all three align and pass the consistency test, right? So you can basically ask if the evidence supports the affidavit, or the affidavit supports the pleadings, or if there are any contradictions. And to make a strong case, you have to keep the contradictions to minimal, right? Now we have a simple file review framework, right? So if you have to quickly go through a case brief, how do you understand? See, so when you start interning with lawyers or when you go before the court, at times there'll be matters which you'll forget, or your senior will tell you that go to this court and go and appear before the court. You will be worried as to that I have not read the file. How do I know what the case is about? It has happened to me also in juniorships that the senior will randomly tell that go before this court and appear in this matter. So, does anyone have any question? Yeah. So when such a situation arises that you have to go before the court in urgency, That time you have to simply go through these 5 things so that you know something about the case, right? Because at times the judge will ask you about the case, and as a junior, or yeah, as a junior, it will look very, very bad on your part that you don't know the case. When you'll answer the court that, oh, my lord, I don't know about the case, or my senior has sent me, that does not leave a very good impression before the court. So you'll go through these quick 5 rules, right? One, you'll quickly go and check what relief is sought. Where will you find that? So your pleadings end part of it will tell you what relief is sought, right? You have to identify what the core dispute is, right? Then you have to highlight what are the admissions and the denials, right? You have to see if there is a timeline, okay, if your senior has mentioned any timeline. If not, then you have to find out important timeline which is essential for the case, and what evidence, the supporting evidence, what are timeline and crucial issues that you identify. You have to see what evidences do you have in the case brief regarding the same, right? So a good lawyer will not merely read documents. They identify the story, they test the evidence, and they also try to find what weaknesses are there. It is not just important that you make your case strong, it is also important, equally important, for you to know what weaknesses are there in the case and what the other side will argue considering your weakness, right? So it is essential for you to know the story, the evidence, and the weaknesses of your case, right? I'll end the presentation so that I can take your questions. Just a second. Yes. Hello all. I have opened the dice for questions. If there are any questions that you have, please feel free to. Yes, I have a request. Could you please teach the first? 1 second, I'll go through the comment section. Okay. Hello, good evening. In case of family court issues, who said false dowry case or domestic violence, then what evidence can we provide? Right. Tirthankar Mishra, can you elaborate your question, please? You can switch on your mic and tell me what your question is.
Hello, ma'am. I was saying, like, if anyone says like false dowry case, like they were demanding, they were torturing, but actually that was not a fact, but nothing proof is there, then how that case runs, and in that case, what is the steps?
Uh, Sorry, can you just repeat? I'm sorry, I lost. Yeah.
Like
So
in
you, yeah.
in family court issues happen, like they say dowry, they are asking like false, they say, and like domestic violence, or the
Okay.
in that case, what proof evidence?
Okay, so you mean to say that if there is no evidence or there is a false dowry case, and then how to prove it, right?
Right.
Yeah. So if your stance is that it is a false dowry case, you will have to identify or show it to the court that how we've never made any claims, right? Or basically, first thing first, if they are claiming that dowry was a part of the this thing case, then they have to prove how the dowry was demanded, right? So for that, they'll have to show that how a case is made out. Okay, so while showing that, they'll have to show that if there is any cruelty or harassment that had happened, or if there are any proofs that you were demanding cruelty, or if any physical violence, CCTV footages, messages explaining how dowry was demanded, or cruelty through actions. So basically, while a dowry case is framed, they'll have to show how that case holds ground through proofs.
Okay, ma'am. Thank you.
Yeah. Anyone else? Yeah. Then Chinmay has this thing that can you please teach the first part of the session? Chinmay, I'll take it towards the end. I'll first address if there are any questions. Manisha, okay. As someone who is first time going to read Barracks, it is going to be somewhat difficult to read the Barrack as well as judgment. So can you tell some note making techniques that would help us to make it easy? Manisha, right. So, Manisha, I totally understand your question. It is a very good practical question that you've asked. So, in the session, I have explained how you go through the Bear Act, right? Bear Acts are important in general, like even if you pursue law as a profession, that you become an advocate, or if you wish to become a judge, or any part, right? Your Bear Act is the most simple statute book that will tell you what the law says, right? So, Bear Act is an essential exercise, and I believe as students of law, we should be in a habit of reading Bear Acts because you know the law better through Bear Acts, right? Now, you're asking me about judgments. See, judgments reading would be tedious, I understand. You are law students, and reading judgments at times becomes a little hectic. What I would suggest here is if you could read commentaries instead, so that you'll understand the provision or the section, and simultaneously you can know the judgments or what important cases were decided on that particular section of the law. So I believe reading commentaries would help you at this stage, or else you can go for judgment briefs or summaries initially. However, I don't recommend that exercise because the more you read, the finer you will get in your knowledge and practice. Yeah, but for starters, you can go with bare acts and commentaries and summaries. However, eventually, when you read more, I would still suggest that you can do an exercise of one judgment a day, be it small or big judgment, but one judgment a day would really help you in shining in your career. Right? Anyone else? Ma'am, share some tips on how to understand bare acts better. You want me to retake the session, Chinmay? I think the session started with that. Chinmay, can you switch on your mic?
Hello, good evening, ma'am.
Hello. Hi, good evening. Good evening, Chinmay.
Sorry,
Tell
ma'am,
me.
my mistake. I was unable to join the session earlier, so I missed that part.
Oh, okay, 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 okay. Okay, so I understand that was your problem. I thought that I was not clear enough
No,
while
ma'am, that's
one.
why I asked you earlier to
Okay,
teach
so
the
I
class.
will give you a simple now. Since you've missed that part, it's okay. I will
Thank
tell
you,
you
ma'am.
how to, no problem. I'll tell you how to go about reading the Bear Act, the method. So, first and foremost, you have to read the title because the title will explain you what the intent of the legislators was behind enacting that particular law. So, it is essential that you read the title so as to know whether your case is maintainable, right? We often see that the lawyers challenge the maintainability of a particular matter. And how do they challenge that? Because they know that a particular statute does not cover or give protection for this kind of case. So, for that, you need to know what was the legislative intent behind enacting that particular law, and your title and your preamble will tell you about the same. Then, second most important thing is definitions. You should never, never, never ignore definitions because the definitions will give you legal meaning of simple words, right? So, in normal parlance, person could have a simple meaning that a person is a male or a female or other genders, right? A person. However, legally, a person also includes an association and a company, right? So if you don't read the definition, you will construe person as a normal, ordinary English person, and you'll not take the broader meaning of company or association, right? So a person has to pay tax, but a company also has to pay tax. And how do you know a company has to pay tax? Because the definition of person includes company, right? So definitions you should not miss. Secondly, then third, you have to mark important words like may, shall, and or, because these words look very simple, but they entirely change the legal meaning and distinguish the session from an ordinary meaning, right? So words like shall basically creates an wait, so I'll just brief you in a more this thing. 1 second. Yeah, I'll tell you everything. So basically, shall will give you a mandatory meaning, right? So the authority shall issue notice. I'd taken that example in the session earlier. Shall will give it a mandatory meaning, right? May will give it a discretionary meaning, that the authority may issue a notice. So may becomes discretionary and will include that all the conditions have to be met, right? So basically, it will have, so again, I'd explained it in the example that grave and sudden provocation, right? So grave and sudden provocation is an exception in your IPC, right? Grave and sudden. Here, there is no choice between grave, sudden. Both have to be there. And the important Kame Nanavati case was decided on that one word of and, that the case was grave, however, it was not sudden. The entire preparatory time was not sudden. Therefore, and means it is essential that all the conditions are satisfied, right? So, and gives that meaning, or gives alternative condition, this or that, right? Then includes will have a more larger meaning, it expands the meaning, right? Means will have a very particular meaning. Suppose I say, 1 second, just a second. Yeah. Okay. Means will give it a very narrow meaning, that only this particular. So if I say that, what, how do I give an example? Okay. So if I say that this means white, so it will be narrow. Only this means white, right? This will not mean white. So means will give it a narrow meaning, but includes will give it a more broader meaning. If I say this includes white, so something which is like this of white will also be included in it, right? So it will be a broader definition. Then what are the words? Okay, then you have to read the provisos, you have to read the explanations, you have to read the exceptions. That's basically how you read a Bare Act. And simple words like may, shall, includes, etc. will in entirety change the meaning of what you are pleading or what the other person is saying. Hence, there is a difference between when a ordinary person or a layman drafts a particular agreement or a contract and when a legal professional does it, because they know the meaning of such words which look very normal English or ordinary English will have an entirely different meaning when it's a legal usage. Okay. I hope that was uh, like a quick summary for you.
Thank you so much, ma'am.
Welcome. Yeah. Anything else? Does anyone have any other question? Sakshi Gadam wants to know about internship. Sakshi, where are you from? Can everyone switch on their cameras? I would like to see everyone. I would like to see all the participants. Quick, quick, quick. I'll be very happy to see all your faces. Perfect. You can go ahead and ask questions, whatever questions you have. I'd kept the session a little brief so that I can take more questions from you. Yeah, so who was asking me? Yeah, Sakshi Kadam, you were asking me about internship. Where are you from? If Sakshi is still in the meeting. Okay, I think that's all. No more questions.
So, ma'am,
Yeah.
does anybody still have questions or? Okay, if that is it, thank you so much, ma'am, for the insight. Participants now have a much clearer understanding of reading legal language and what it takes to build a successful career in law. So, to conclude it, as we have come to the end of today's session, I would like to extend our heartfelt gratitude to Advocate Sanskruti Mahale ma'am for taking the time to share valuable experiences, practical knowledge, and insights with all of us. So before you leave, we request all of you to kindly fill the feedback form that we have shared in the chat, and your feedback will definitely help us organize more meaningful and impactful sessions. So, and now let us take a virtual group photo, and I request everyone to kindly switch your cameras on and join us for a photo, please. Can everyone please turn your cameras on? So thank you everyone for joining us today, and we are looking forward to see you again in upcoming sessions as well. And
Thank you
have a
so much,
great day
ma'am.
ahead, and stay connected to the collective council.
Thank you all. I hope the session was